Hi, I'm Kath Debreceny, a partner in our corporate team at Maddox, and today I'm chatting with Gina Wilson, one of our dispute resolution and litigation partners, about the impact that COVID-19 has had on directors and officers. We'll be looking at new challenges and risks created by the crisis, including both financial and non-financial risks. And we'll be talking about what directors and boards should be doing right now to manage the crisis appropriately and mitigate future risks that might arise as we come out of COVID-19. Welcome, Gina.
Thanks, Kath.
So just to start at the beginning, we seem to be slowing down in the pace of change here. What are you seeing in terms of the risks to directors and officers coming out of the crisis?
Yeah, well, Kath, it has been a constantly changing environment that we've all had to adapt to really quickly. And I think in terms of boards and management, they're being forced to make business critical decisions, often really quickly, to adapt to the changing circumstances. These decisions often have potential long-term consequences for the business, without any real certainty around what the future actually looks like. So I think COVID-19 is certainly creating a lot of financial and non-financial risks for businesses, and the big issue for boards is to try to get their head around what those risks are, to understand them and make sure that they have business continuity plans and mitigation strategies in place to address those risks. A second big issue as well, particularly for listed companies, is ensuring that disclosures are made to investors of any material impact on profits which may be caused by COVID-19. And certainly from the perspective of the corporate regulator ASIC, these two things are big ticket items for them that they will be keeping abreast of and watching.
Right. So continuous disclosure being a big issue.
Absolutely.
When you say financial and non-financial risks, what sort of risks are you seeing arising from speaking with your clients?
Yeah, we've seen a lot of different risks, across the board with business interruption caused by COVID-19 or government restrictions which have been limiting movement. So this has had flow-on effects for supply chains, where the businesses themselves are struggling to meet their contractual obligations, or they're unable to procure the supply of essential goods in the supply chain. We've seen a number of instances where parties are trying to get out of contracts or renegotiate deals, and that raises questions around whether there are force majeure provisions or material adverse change provisions in the contracts which deal with these particular circumstances, or whether COVID-19 itself is a frustrating event which can relieve the parties of their obligations moving forward. Another big item for us, purchasers' ability to settle on significant property transactions. So we've seen that the funding issues being caused by COVID-19 has meant that many purchasers aren't able to complete. On the other side of the coin as well, we've also seen some purchasers opportunistically taking advantage of COVID-19 to try to get out of contracts that they no longer want to proceed with. Another big one is safely managing the workplace from an OH&S perspective and ensuring that all reasonable steps are being taken to provide a safe workplace. So this is particularly important where you've got those businesses that are continuing to have a core workforce on the ground and they're providing essential goods and services to the public throughout the pandemic. And I think another big thing we'll see moving forward is how workplaces manage the integration back, when the restrictions start to be lifted. There's also many issues arising out of the changes in the ways that we work, and including privacy and data breach concerns with so many employees working from home. And I'm sure, Kath, from your perspective as well, you've probably seen a number of other risks in the clients that you're advising, as I expect COVID-19 has had impacts on M&A activity, equity markets, inability to meet banking covenants and things of that nature.
Yes, we're seeing it's very hard to make a decision when you don't know what's going to happen in the future. So for M&A deals, it is a difficult time to be starting on a transaction and evaluating correct purchase price. On equity capital markets, we're seeing some extra cash being raised to enable businesses to get through this time and to set them up hopefully for growth when we come out of it. So given that there's such an avalanche of change and items that people have to be aware of, what sort of practical advice are we giving directors and boards about what they should be doing right now?
Sure. Well, I think, Kath, we're certainly in unprecedented times here, and we don't expect boards and directors to have a crystal ball and be able to predict with certainty what's going to happen. But I think first and foremost, directors should be promptly and proactively seeking to understand the anticipated effect of COVID-19 on the business and making sure that they have plans in place to deal with those. What it does require is a thorough review of any existing compliance or contingency plans to make sure they do respond. If they don't, amend them, or if they don't exist, create them. More generally, we'd suggest doing an audit of the company's contracts and financial arrangements. So work out whether you're going to be able to comply with your obligations under those. And if it becomes apparent that you can't, be proactive in commencing discussions with counterparties to try to extend timeframes or vary obligations. So really getting on the front foot there. If you're in any doubt at all about the company's solvency or its ability to perform its contractual obligations, seek professional advice. Secondly, the board needs to determine whether the current situation requires any disclosure to the market, particularly in the context of any previous disclosures or forward-looking guidance that might have been given. As you would know, any failure to make required disclosures under the ASX listing rules can expose the company and its directors to liability and also potential shareholder class actions. And we've certainly seen a bit of activity in terms of securities class actions in the US already, not surprisingly. So that's a bit of a watch this space. The ASX did release a compliance update at the end of March, which gave some guidance in relation to COVID-19 and continuous disclosure obligations. Did acknowledge that you can't predict the unpredictable, but did give some helpful advice that is certainly worth looking at. And in relation to entities who hadn't reviewed their published guidance in light of COVID-19, strongly encourage them to do so. Finally, we'd also recommend that COVID-19 be a standing agenda item for board meetings, and continuous disclosure, obviously, to be a standing item as well.
Great. I think while we're not expected to manage unknown risks at the moment, I do think that we'll be judged looking backwards. So we'll be judged with the benefit of hindsight. And so I think one of the things that people should be doing is writing down the justifications for the decisions that they're making, because they seem logical and the best that we can do right now in these circumstances, but it'll be hard to judge whether they were correct with the benefit of hindsight. So writing these things down. You mentioned insolvency and particular concerns about making sure that you're not trading while insolvent. Can you just explain the safe harbour provisions that were introduced to protect directors during this period?
Yeah, sure. So basically during this 6-month period, there can't be action taken against directors for insolvent trading. But having said that, any debts they do incur during this period need to be incurred in the ordinary course of business. So it doesn't give you a grant basically to go off on a frolic and incur debts willy-nilly without properly considering whether they are necessary expenses to be incurred in order to ensure the continuing viability of the company moving forward. The 6-month moratorium period, I think, is going to provide the necessary protection for companies that are likely to come out of this at the end of the 6-month period. I think the greater concern is companies that are really struggling financially anyway, and may well have been before COVID-19 hit. After the 6-month period, if their financial viability still isn't sort of guaranteed, there's some real issues there for directors of those companies. So it really does place the onus on the directors to be continually assessing the solvency of the company, bearing in mind that any debts they incurred during the moratorium period are still going to be payable at the end of that period. And in proactively thinking about the position of the company, I mean, having a look at the options and, possibly external administration during this period might be an option they need to seriously consider if solvency remains.
And what about protection that we can obtain through directors and officers' indemnity insurance?
Sure. So the safe harbour provisions, I should have added, won't provide protection to directors and officers in terms of any liability they have for breach of directors' duties. D&O liability may well respond to allegations that might be made against directors arising out of these particular circumstances. So things you could imagine in terms of allegations could be that the company hadn't acted appropriately to protect the business from a pandemic of this nature. Or that once the pandemic hit, the directors didn't act quickly enough and appropriately enough to address the impact on the business. And those directors' duties include acting in the best interests of all stakeholders, which could well include creditors. So again, the solvency concern comes to bear there as well. So having said that the D&O liability may cover breach of directors' duties, there are exclusions policies. So the particular policies that you have would need to be considered to make sure that they do respond to these circumstances. So may offer protection, but may not.
I guess that leads to my final question. Should directors be worried? And I guess it's pretty clear that they should.
Yeah.
But a bit more on that one.
Yeah, look, I mean, we're certainly in unprecedented times, and as I think you mentioned, Kath, we're all just trying to do our best to deal with things as and when they arise. And the goalposts haven't shifted there. Provided directors are always doing their best, keeping abreast of information, acting in the best interest of the company, they're probably going to be okay. And there are defences that are available to them. So we've obviously got the business judgment rule that will protect them in terms of breaches of some of the directors' duties. And there's also a provision in the Corporations Act which relieves directors and officers from liability, or fairly excuses them, I think is the terminology that's used, where they've acted honestly and diligently and at all times in the best interests of the company. And this seems to be, a circumstance where this provision would really be suitable. So I think, don't be too concerned about it, but just be diligent in making sure that you're aware of all the risks and that you've planned appropriately to deal with them.
Great. Okay. Thank you, Gina.
Thanks, Kat.